If you own a home and you have even one question in the back of your mind about what happens to it when you're gone, maybe you have a will. Maybe someone told you your deed is sorted. Maybe you've just been putting it off because it's complicated. Whatever your situation is, give me 10 minutes. By the time this video ends, every confusion you have about wills, deeds, trusts, and probate, gone. Completely gone. And if you think you've already done everything right, stay till the end. Because the one mistake I'm going to show you is the exact mistake people who think they're protected are still making. 10 minutes. Let's go. What actually happens to your house when you die? Your house doesn't automatically go to your kids. It goes to a process called probate. Probate is basically a court taking control of everything you owned and deciding how to handle it. Even if you have a will, even if your family all agrees on who gets what, the court still steps in, the court still supervises, the court still decides the timeline. And here's the part nobody talks about. Probate takes 9 to 24 months on average in the United States. That's up to 2 years where your family cannot freely sell the house, cannot transfer it, cannot do much of anything with it. But the mortgage still due every month, property taxes still due, and if the estate runs out of cash during that time, the house can go into foreclosure. Your family could literally lose the house while waiting for a court to hand it to them. And that's if everything goes smoothly. Add a family dispute, a missing document, or a creditor claim, and that 2 years turns into 3, 4, even longer. Some probate cases have taken decades to resolve. Decades. How much it costs your family? Probate costs 3 to 7% of the total estate value. Let me put real numbers on that. Your home is worth $400,000. 3 to 7% means your family loses $12,000 to $28,000 before they get a single dollar. That money goes to court fees, attorney fees, and administrative costs. Gone. In California alone, for a $750,000 home, probate fees hit $36,000 minimum by law, not by choice, by law. And here's something most people don't realize. Everything in probate court is public record. Your home's value, your debts, your family disputes, anyone can look it up. Creditors, lawyers looking for cases, anyone. That's the system. And it's working exactly as designed, just not for your family. Now, I know what you're thinking. I have a will, so I'm fine, right? No, you're not fine. This is the biggest misconception in estate planning. A will does not avoid probate. A will is just a letter you write to the judge. It still goes through probate court. It still takes months or years. Your family still pays those fees. The will just tells the court what you want. The court still decides when and how it happens. Unlike a will, a living trust does not have to go through probate court at all. That's the difference. A will says, I want my daughter to have the house. A living trust says, my daughter already has the house. No court needed. What a living trust actually is. So what is a living trust? It's a legal document you create while you're alive. You put your house inside it. You name yourself as the one in charge, so nothing changes while you're alive. You still live there. You still own it. You can still sell it, renovate it, do whatever you want. But you also name someone, a spouse, a child, a sibling, to take over when you're gone. When you die, that person steps in immediately. No court, no judge, no waiting. Trust distribution typically takes 30 to 60 days versus 12 to 24 months through probate, 30 to 60 days. Your daughter gets the house within 2 months, not 2 years, and it's completely private. No public record, no court filing. Now, how much does this cost? A basic living trust with an attorney costs $1,000 to $3,000, one time. Compare that to $12,000 to $28,000 in probate fees your family would otherwise pay. It pays for itself many times over. The one mistake that kills even good trusts, here's where I need you to pay close attention, because this is where people who did everything right still get it wrong. Creating a living trust is not enough by itself. After you create the trust, you must transfer your house deed into the trust's name, not your name, the trust's name. If your deed still says John Smith instead of John Smith Living Trust, your house goes straight to probate court. The trust document is perfect. The house deed is wrong. Probate happens anyway. This happens to families all the time. They paid for the trust. They thought they were protected. They weren't because nobody updated the deed. So there are 2 steps, not one. Both are required. Step 1, create the trust. Step 2, retitle the deed into the trust's name, both, or it doesn't work. What you do right now, 3 actions. Do these in order. First, pull out your house deed right now. Look at the name on it. Is it your personal name or a trust name? If it's your personal name, you're exposed right now. Second, contact an estate planning attorney. A basic living trust runs $1,000 to $3,000. Some online services do it for under $500. Either way, get it done. Third, after the trust is created, have your attorney retitle the deed into the trust's name. This is a simple one-page document. It costs $50 to $200. But it must happen, or the trust is useless for your house. That's it. 3 steps. Your family is protected. Look, I know nobody wants to think about this, but you didn't spend 20 or 30 years paying for that house, so a court could freeze it for 2 years and take $20,000 out of your family's inheritance. Right now, 56% of Americans have no estate plan. That number hasn't moved in years. Don't be in that group. The families that get this right aren't wealthier than you. They're just one step ahead. If this video helped you, share it with someone who owns a home and hasn't done this yet. You might be saving their family more than they realize. 1-minute recap section. All right, let's do a quick recap before you go. Your house does not automatically go to your kids when you die. It goes to probate court, which freezes your home for up to 2 years and costs your family $12,000 to $28,000 in fees. A will does not protect you. A will still goes through probate. It just tells the judge what you want. The court still controls everything. A living trust is the solution. It bypasses probate completely. Your family gets the house in 30 to 60 days, privately, with 0 court involvement. But creating the trust is not enough. You must retitle your house deed into the trust's name, or probate happens anyway. 3 steps. Check your deed. Create your trust. Retitle the deed. That's it. That's everything you need to protect your home and your family. Now let's get it done. Next video, I'm breaking down exactly how a living trust works step by step, what goes inside it, and the mistakes attorneys see most often. See you there.